Hearing in the appeal Halliburton Company against Chubb Bermuda Insurance Limited.
Now, Lord Grabbanach, there are two matters I think I should raise at the outset. One is to let you know that as we're starting at 10, we would propose to have a short break at about 11:30, if you find a convenient point. The other is that we've been given in draft an anonymity order. I have to say it's not apparent to us what justification there is for making such an order in this case, or indeed for preserving the anonymity of some of the parties to the proceedings. You may wish to address us on this at a later stage, or you may prefer to put in written submissions on the matter, but we will need to be persuaded before we make such an order.
We are entirely neutral on the issue, my Lord. This has its origin through the historical process of the litigation. Mm-hmm. I intend simply to use the initials M and N, hopefully without confusing anybody. But we don't have a position on it. I don't know if any of my friends do have, but I'm sure it can be dealt with at some stage anyway.
Yes. Very well.
May it please the Court, and we're grateful to the Court for giving us the extra time as well. I appear for Halliburton with my friends Mr. Kitchener and Mr. Draper. For Chubb, my friends Mr. Cray, Mr. Landau, Mr. Scory, Mr. Peters. The first interveners are ICC, Mr. Partasides, Mr. Jane and Ms. Peart. And for the LCIA, the second intervener, my friends Mr. Kimmins and Mr. Pierce. There are other interveners, but not on the basis that they make any oral submissions. So, my Lords, we've formulated a question for the Court, which we think fairly reflects the issue. And it's this: does English law require a party to submit its disputes to an arbitrator who has breached his legal duties to that party and whose conduct has generated the legitimate concerns identified by the Court of Appeal? And, my Lords, that we say is the question, and the question arises in the context of two related issues. The first issue is where you have the same arbitrator in two related arbitrations, where one of the parties is a party to both arbitrations, but the other is a party to only one of them. And because of the private nature of arbitration, the arbitrator and one of the parties will have full knowledge of both arbitrations, but the other will not. And there's an obvious risk, we say, that the arbitrator and one of the parties will share knowledge and information unknown to the other party. That knowledge and information is the result of ex parte communications by definition, and they are expressly prohibited by the terms of appointment. The terms of appointment have not figured greatly in the history of this litigation, and indeed I think I'm right in saying the document doesn't even figure in my friend's written case. But I want to draw it immediately to the attention of the Court. On the electronic bundle, it's 0611. And we're looking only at one clause, clause 9. For present purposes, I'll come back to it later. It simply says this: the parties agree that there shall be no ex parte communications between any party or its representatives and any arbitrator regarding any matter in these proceedings, save in respect of routine administrative matters, and that all written communications by one party to the tribunal should be copied simultaneously to the other party. I'll come back to other provisions of it at a later stage in my submissions. We also suggest that that document on what I've just read out really does represent the common law position. Just for completeness, your Lordships will see at the back of that document that it is signed by all three arbitrators, also by the parties, and although the print is very small, it's dated the 23rd of September 2015, and it is a contractual document.
Could you give me the page number again, please?
Got the page number. It's, well, the number on the electronic bundle is 0611.
And the hard copy?
S367.
Thank you very much.
The Court of Appeal rightly accepted in our submission that this issue gives rise to what they called legitimate concerns on the part of the non-common party. And that point is made in a number of paragraphs in the judgment. I'll just give you the paragraph references, but we don't need to go to it. Paras 44, 47, 49, 61 within the quotation, 77, 85, and 87. That's in the core bundle, 187 to 196, 0188 to 0197 in the electronic bundle. Now, those concerns arise from the risk of unfairness to the non-common party, and that's made clear in the judgment at paragraphs 43 to 44. But the Court of Appeal says that something more would be required to give rise to justifiable doubts, which are the words in section 24(1)A of the Arbitration Act. And the Court of Appeal says that in paragraph 53 of its judgment, core bundle 189 and electronic 0190. Now, in our submission, it's not at all clear why something more is required, given that the arbitrator's conduct has exposed the non-common party to the risk of an unfair process. Nor is it clear what that something more might be. The requirement of something more, we suggest, is inapposite in this case, because the party in ignorance will not know what is being said in the related arbitration. So even if there were something more to complain about, the party in ignorance would never find out about it. As to the numerous references in the Court of Appeal judgment to the expression legitimate concerns, we do understand them as references to concerns that would be felt by the fair-minded and informed observer. In other words, they carry with it the objective test, not a subjective test. And that is explained in our submission by the word legitimate. What makes the concerns legitimate is that tested objectively, they are legitimate concerns. In the Cayman Court of Appeal, in the case of Al-Mazidi, and I'll have to look at that case in some detail towards the end of my submissions, but in the Court of Appeal in the Cayman case, it went in due course to the Privy Council. Sir Bernard Ricks said that a judge would have to recuse himself in the face of, and I quote, and there's no need to go to it for the moment, legitimate concerns as to independence and impartiality. The Court of Appeal quoted that passage in paragraph 61 of its judgment, which is at core 191, 0192. And in our submission, Sir Bernard's words are interchangeable with the real risk test for apparent bias, which is the common law test, and they are synonymous in our submission with justifiable doubts as to impartiality, which are the words in section 24(1)A of the Act. In any event, the legitimate concerns are shared by all the commentators. They are not the concerns of an unduly sensitive party. And we contest the point in this way. Would the court tolerate Chubb having private communications with M, touching on the Deepwater Horizon incident, without Halliburton being present, or even knowing about them? In our submission, the answer is obviously no. Similarly, the court would not tolerate M attending an internal seminar at Chubb devoted to the Deepwater Horizon incident over Halliburton's objection. Similar points were accepted by Mr. Justice Fraser in a case which I'll also look at later called Beumer, B-E-U-M-E-R. That's really the first related issue. The second related issue is where the arbitrator, accepting the second appointment, fails to disclose either his intention to accept the appointment which has been proposed to him, or the fact of it, if he then proceeds to accept it. Now, the Court of Appeal rightly accepted that the non-disclosure was a breach of a legal duty owed by M and gave rise to legitimate concerns on the part of the ignorant party. And they reached that conclusion in paragraph 91 of their judgment. That's Core 197 or 0198. The Court of Appeal again held that something more would be required before the non-disclosure would give rise to justifiable concerns under section 24(1)(a). And that's paragraph 76 of the judgment, Core 194, 0195. Now, having held that both issues gave rise to legitimate concerns, the Court of Appeal did not explain why each of them did not supplement the other, so that each of them provided the something more the Court of Appeal thought was missing. Now, virtually all the commentators have pointed out that it is particularly troubling that the Court of Appeal based its decision, at least in part, on the proposition that the parties should simply trust the arbitrator to comply with his statutory duties. They said that, for example, at paragraph 86, Core 196, 0197. Now, that is in part because of the arbitrator's local reputation, which was also emphasised by the Court of Appeal. Paragraph 98, Core 198, 0199. But as Professor McKendrick points out in his Stockholm Centre for Commercial Law paper, he says that trust must be earned and retained. And you'll find that passage in the final paragraph of his paper, which is electronically 2999. English law in our submission does not require a party to trust an arbitrator who has breached his legal duties and whose conduct has given rise to the legitimate concerns identified by the Court of Appeal. It was never enough, by which I mean historically, it was never enough for a complaint to be answered with the response, "Trust me, I'm the arbitrator." It certainly should not be enough these days. It is not an answer to the question, is this a case of apparent bias? The answer that's suggested simply dodges the question. And we suggest that English law should apply a test to arbitrators, regardless of their reputation here or abroad. And it is a great strength of London arbitration that it attracts arbitrators from around the world. Many of them will be unknown to our commercial court. It would be invidious for the parties to be adducing evidence about the reputation of the arbitrator in question. It's actually rather a ludicrous suggestion. There happens to be a fortuity here that M was known locally. It is also important to establish that English law does not regard eminent English arbitrators as somehow immune from unconscious bias. An arbitrator might have a wonderful reputation as a lawyer, but that tells you absolutely nothing about his immunity from the unconscious biases which, if I may respectfully suggest, we all have. Now, can I say something about standards? When answering the question that I posed at the outset, I would suggest that your lordships should have in mind the standards that English law should apply to arbitrators in order to ensure their impartiality. The only possible one we suggest is the gold standard. Or to paraphrase Lord Justice Mummery in the case of AWG Group against Morrison, at paragraph 29, and the reference is Core 084 and I think electronically 0085, but it's set out in our written case at paragraph 103, and it's in paragraph 29 of Lord Justice Mummery's judgment. He says simply this, albeit in a slightly different context: anything less is simply not worth having. Applying any lower standard would be unprincipled. It would damage English law and the reputation of London as the leading centre of international commercial arbitration. That reputation has been hard-won. It is not God-given. London's success is based on its reputation for fairness and impartiality, and there's a survey that was conducted by, I think, Queen Mary University, which we refer to in our written case at paragraph 2. That's the electronic reference 0052, core 051. The commercial court is the ultimate guarantor of that reputation. Now, this is not something about which this court can be complacent, and it is worrying that complacency is the word the informed commentators have applied to the decision of the Court of Appeal. Now, when I say that in England, under English law, we should adopt the gold standard, I should say what that standard consists of in our submission in this case. Now, Chubb says the concerns raised by Halliburton run contrary to internationally recognized standards and have no substance. They say that in their written case in paragraph 3. They also say that our challenge is what they call opportunistic. They say that in their written case, paragraph 14, sub 7, core 107, 0108. Now, I don't want to get into a forensic bun fight with my learned friends. Well, I would actually, but I don't propose to. But your lordships should appreciate the weight of opinion which is supportive of our complaints. The weight of opinion is important, especially here, where we are concerned with the fair-minded and informed observer. There is a near consensus view in the world of international commercial arbitration that M's conduct gave rise to justifiable concerns. That is a very powerful indication of the conclusion this court should draw as to the view of the fair-minded and informed observer. The commentators are leading figures in the field. Many of them have particular expertise in insurance arbitration. Some of them have particular expertise in the Bermuda form. Now, I should just very quickly make reference to those commentators. First of all, Professor N. He was the arbitrator nominated by my clients. He's a man of great eminence and reputation in international commercial arbitration. His CV is at 0618. With the award, he issued something called his separate observations. And we've never seen, I don't think anybody engaged in the case has ever come across such a thing in any arbitration over many years. And between us, I would think there'd be many hundreds of years, literally, and I can contribute most of the hundreds, in all the time that we've ever been dealing with any arbitration cases. But he said this, quote, "The lack of disclosure which causes special concern in the present fact pattern cannot be squared with the parties' shared ex-ante expectations about impartiality and even-handedness, 0594. We suggest that N is a good proxy for the informed and fair-minded observer." Professor McKendrick, he's the professor of English private law in Oxford. He's one of the editors of Chitty. His article on the Court of Appeal judgment is at 2996. His view is that the Court of Appeal judgment, and I quote, "was wrong and wrong for a number of reasons," end quote, and he gives 7 reasons. He is strongly critical of the Court of Appeal's reliance on trust in the arbitrator, and we deal with that in our written case, paragraph 65, core 071 0072. The next independent commentator, my learned friend Paul Stanley, QC, is co-author of Liability Insurance in International Arbitration, the Bermuda form, so it's a book that's devoted to the Bermuda contract. His article is at 3161. It is, I would respectfully suggest, a balanced and carefully argued contribution. He comes down strongly against the Court of Appeal judgment. He notes that the lack of transparency in arbitration requires a strict approach to factors that might otherwise be safe, for example, in ordinary High Court proceedings. We deal with that in our written case, para 92, core 078 0079. And he expresses the view that multiple appointments in overlapping arbitrations should prima facie be disqualifying. And we deal with that in our written case, paragraph 98, little b, core 0800081. Christopher Hancock QC is head of chambers at 20 Essex Street. They're one of the leading chambers doing Bermuda form work. He's also a supporting member of the Maritime Arbitrators Association, which means that he sits as a maritime arbitrator as well. His article is at 3043. He is particularly critical of the Court of Appeal's suggestion that because Halliburton challenged M for apparent bias, M could now, in the light of having been the subject of the complaint, be expected to act without bias. That's dealt with in paragraph 147 of our written case, core 0970098, and the relevant passage is at 3050. Next, the Chartered Institute of Arbitrators, who have intervened, but I don't think have a right to speak. They speak for the views of their 16,000 members. They say the Court of Appeal was wrong to take into account M's reputation. They say the court was wrong to reason that M could be trusted to self-police for unconscious bias, and wrong to conclude that accepting multiple appointments in related references with only one common party cannot by itself give rise to apparent bias. My learned friends appearing for the LCIA and the ICC will make their own submissions. The major law firm, US law firm Covington and Burling, says that in light of the Court of Appeal's judgment, policyholders should not accept London as an ad hoc arbitral seat. We deal with this in paragraph 9 of our written case, 025 of core, 0026. The article is at 2953. Now, I've talked about the gold standard. In any event, your lordships should not, in our submission, adopt any standard below the one suggested by the LCIA, the ICC, and the Chartered Institute. They personify the international arbitration community and the fair-minded and informed observer. Now, as to the few dissenting voices, they come from niche areas of arbitral practice. The special contexts in which they operate are quite different from the general international commercial arbitration we're concerned with here. Mr. Gaunt of the Maritime Arbitrators Association distinguishes LMAA arbitration from general international commercial arbitration, as he puts it, in his witness statement at paras 12 and 41. The international commercial arbitration textbooks make little reference to the LMAA rules and the GAFTA rules, which are in very key respects specifically adapted to deal with the issues that arise in the context in which they apply. An obvious example is GAFTA's rules dealing with string arbitrations, where you've got buyers and sellers in a line, and where commodities have been sold in a chain of contracts. In our supplemental written submissions, we refer to the LMAA provisions and the GAFTA rules, which permit consolidation of claims. I don't even think you need agreement from the parties. I think it can simply be imposed by the relevant arbitral association. And also the sharing of documents and information in related arbitrations. None of these powers are available under the Arbitration Act except by consent. So if you do consent to that, you can do it, but otherwise they don't figure in our own Arbitration Act. So if I can turn to suggest our answers to the two issues I've identified. So the first issue, as to whether an arbitrator can accept appointments in multiple references concerning the same or overlapping subject matter with only one common party without giving rise to an appearance of bias. Chubb says that in its written case that our answer to that is you can never do that. That is not correct. We say, in light of Al-Mazidi, acceptance of such appointments will ordinarily give rise to an appearance of bias, but not always. We respectfully agree with the LCIA. It depends on the facts. In an LMAA or GAFTA arbitration, the parties have signed up to a system where multiple appointments in related arbitrations are commonplace. The parties benefit from special rules to ensure that unfairness simply doesn't arise. Outside those special contexts, where the arbitrator accepts appointments in related arbitrations with only one party, then at least potentially he is conferring a benefit on the party that nominated him at the expense of the other party. If that advantage can be neutralized before the nomination is accepted, then the problem can be dealt with. It is immediately addressed. If the arbitrator discloses his intention to accept the second appointment, the non-common party may agree. It will have the opportunity to point out the risk of overlapping issues and to register its objections. The parties and the arbitrator can consider the significance of the risk and how it can be mitigated. It might be possible to consolidate the arbitrations or to put in place some system of transparency, for example, by way of mutual disclosure of pleadings, of evidence and submissions. If that is done, the position might well be acceptable. Also, the arbitrator will have displayed, and this is an important point, a proper concern for the legitimate interests of the non-common party. And that's one of our real concerns in this case, because we didn't get the benefit of that. The second issue is whether and to what extent, without disclosure, the arbitrator may accept appointments in related references with one common party without giving rise to an appearance of bias. Our answer to that question is never. There is no justification for non-disclosure, and no supporting argument has ever been identified. And for this purpose, we rely on, and I'm sure these are references which your lordships are very familiar with, Lord Bingham and Lord Hope in the case of Davidson. Lord Bingham is at paragraph 19 of that judgment, and Lord Hope at paragraph 54. The references are Core 094, 0095, the authorities bundle 0114 at 0988, and Lord Hope at, that's Lord Bingham, and Lord Hope at 0997, authorities bundle 010123. I take it that your lordships are very familiar with those passages.
Well, I think some of us have known these cases for a very long time.
That's what I thought. I wasn't proposing to go to them.
We've all read the judgments below and the written cases.
Lord, I'm grateful. I won't go to them now in the interest of time, but they are very critical passages and they're smacking point as far as we're concerned. I would add also the observations of Mr. Alexis Moore, which I think is how you pronounce it, M-O-U-R-R-E. He's the president of the ICC court. We deal with that in our written case at paragraph 133. In the core bundle at 092 and the electronic 0093, the speech is at 2906. And I would strongly commend that speech to your lordships because, again, it is completely in point and it is precisely in accord with the observations of Lord Bingham and Lord Hope. Now, if disclosure is given, the parties can discuss the position. The non-common party can explain the risk of overlapping issues. It can object to the second appointment. It or the other side can propose mitigating steps. The arbitrator can take an informed view as to how to proceed. Again, he will have shown a proper regard for the legitimate interests of the non-common party. And we say an arbitrator must not, without disclosure, accept appointment in related arbitrations with only one common party. Now, it doesn't follow that any non-disclosure of any fact that ought to be disclosed must result in disqualification. It certainly doesn't follow. That has never been our position. The non-disclosure here is disqualifying for several reasons, and perhaps I can identify them. First of all, it should have been obvious to M that disclosure had to be made. He would have done so if he had had regard to Halliburton's interests in safeguarding the fairness of the procedure. Secondly, there is no explanation for M's failure to make disclosure beyond oversight. It is not a case in which the non-disclosure can be attributed to an imperfect memory. It was a failure to disclose something the arbitrator was actually doing at the time with one of the parties. Thirdly, the fair-minded observer would not tolerate the failure of a decision maker to disclose a developing relationship with one of the parties. Still less would the fair-minded observer tolerate the non-disclosure of a connection that gives the decision maker a benefit and confers a benefit on one party to the detriment of the other, still in the dark. And fourthly, the failure to disclose compounds the unfairness, regardless of whether Halliburton would have been able successfully to challenge M's acceptance of the second appointment. It should have been told about it so that it could protect its interests. As Mr. Rumsfeld would say, it's always better to know what you don't know. A very good example of it. Many non-disclosures will have none of those features, and the consequence of a non-disclosure must accordingly, in our submission, turn upon the particular facts of the case. Now, Chubb says that it's okay for the arbitrator to adopt a wait-and-see approach, so I want to address that point. They say that in their written case at paragraph 31, core 115-0116, and they say this: it was entirely proper for him to continue to sit on the Transocean Tribunal and to consider his position if and when a conflict arose, end quote. On that approach, an arbitrator can accept an appointment without disclosure and wait and see if it gives rise to overlapping issues. That's the effect of what's being suggested. And then, if it does give rise to some problem, he can then disclose it. That argument was deployed in the Court of Appeal and, for good reason, was rejected. The short answer to the wait-and-see point in this case is that it's a pure fiction. M did not decide to wait and see. He never actually turned his mind to the problem. He paid no interest to, or no regard to the interests of Halliburton. That's our complaint. But setting that aside, let's assume that I'm just dealing with the argument that wait and see is a legitimate way of going about dealing with this kind of problem. In any event, we suggest that a deliberate wait and see approach would give rise to many problems. It would likely lead to an allegation of actual bias because it involves the arbitrator having appreciated the potential conflict but deciding to keep it to himself and not to reveal it, and then to make his own judgment about it at some future time. Also, one has to bear in mind a number of other related problems that this would give rise to. Both arbitrations might have progressed at considerable expense. Without consent of all the parties, the arbitrator is prohibited from explaining in one arbitration the issues in another. There might be particular issues concerning the position taken by a party in one arbitration, which creates sensitivity, for example, because the party has taken inconsistent positions. That's exactly what happened in the case of Boima, which I'll show you in due course. But the arbitrator will not be able to disclose that. If the parties are unable to agree an amicable solution, the arbitrator will have to resign from one reference or possibly both. And if he does that, he might then be liable for damages for breach of contract. He's protected under the 1996 Act from proceedings against himself, but if he resigns, then he does expose himself to the risk of a damages claim. He will be professionally embarrassed. That embarrassment would be magnified by the fact that he had not made disclosure at the earliest opportunity. In all the circumstances, the arbitrator would have put himself in a position in which his interests were conflicting with his duties. His interest would be not to disclose, and that interest would be shared with the common appointing party. That has resonance in this case. When the problem was identified, M took the position that it might be resolved if the preliminary issue in the Transocean arbitration was decided one way rather than in another. So he actually said, well, it won't be a problem, it might go away because as a result of a separate issue that's going to be argued out in the Transocean case, this problem may become literally academic. The reference to what he had to say on that point is at 0638, 0639. It's the penultimate paragraph of the particular letter. So I'm not suggesting there was anything nefarious in him adopting that position, but it was, with respect, unfortunate. Related to the wait-and-see argument Chubb says that the court's assessment of the legal consequences of a non-disclosure should be tested at the date of the hearing of an application to remove. So this is a point I want to go to the judgment on in the Court of Appeal. Chubb makes that point in their written case, paragraph 14, subparagraphs 5 and 6, Core 107, 0108. Mr. Justice Popperwell adopted this approach, but the Court of Appeal disagreed. Could we take up the judgment of the Court of Appeal at paragraph 70? So that they set out the discussion and they deal with what was said at first instance. At para 70, if your lordships would just read it through, but in particular between C and D, they say, in this regard, we disagree with the approach of the judge who considered that the issue of whether disclosure ought to have been made was to be determined retrospectively by reference to whether, having regard to all matters known at the later stage to the fair-minded and informed observer, the circumstance would lead to the conclusion that there was a real possibility of bias. And then in 71, we consider the present position under English law to be that disclosure should be given of facts and circumstances known to the arbitrator, which in the language of 24 would or might give rise to justifiable doubts as to his impartiality, and so on. They make much the same point if you go forward to paragraph 83. They say in the third sentence, for reasons already given, we agree with Halliburton that the issue of whether disclosure ought to have been made has to be addressed at the time when disclosure potentially falls to be made and not with the benefit of hindsight. In this case, it should be considered at the point M took the decision to accept the Transocean appointment. And then curiously, if your lordships would be kind enough to go back to paragraph 81, just further up the page, they seem actually to fall into exactly the same trap. For reasons already given, the mere fact of overlap does not give rise to justifiable doubts as to impartiality. In any event, the degree of overlap in this case was in fact very limited. References 2 and 3 were decided on the basis of a preliminary issue of law that did not arise in reference 1. The facts never had to be investigated. So they appear then to be looking backwards in a way which is precisely the way which they thought was inappropriate. They were, in our respectful submission, entirely right in paragraph 83, 70 and 71. But paragraph 81 somehow or other got in there, but is inconsistent with, in our submission, the correct analysis. The decision of the Court of Appeal on this point, on the 2 paragraphs or the 3 paragraphs I'm happy with, so to speak, is consistent with Lord Hope's observation in Davidson at paragraph 54. The point in our submission does fall to be tested at the outset, that is when the disclosure ought to have been given and not after the event. Now that point was not appreciated by M, who said in his email of the 5th of December 2016, he said this is at 0638, at 0639. He said, in the event, and I quote, no damage has been done, unquote. He's taking the position, no harm, no foul. Now this misunderstanding of the position is a regular theme in Chubb's case. For example, in their written case, at paragraph 14, subparagraphs 6 and 7, Core 107, 0108, they say, the omission was, as it transpired, immaterial. So they do the same exercise. They look retrospectively. That's Core 109, 0110 and 38. And then they say, quote, something which did not damage Halliburton at all, end quote. Core 117, 0118. So they persist in pressing the line that it's a legitimate exercise to look at the thing in the round after the event and to say, well, there was no serious injustice here, so what difference does it make, is the sort of general gist of the point that they seek to make. Now, we respectfully agree with the commentators. The decision of the Court of Appeal leads to a strange result, a breach of a legal duty of disclosure, but no consequence. Chubb says that it's common for legal duties to be breached without a remedy. They give the example of a breach of a duty of care, but there's no damage. They say that in their written case at paragraph 65, Core 139, 0140. With great respect to my learned friends, that analogy is entirely false. If you want to bring a claim for negligence, damage is an essential requisite of the tort. Trespass, admittedly, is actionable per se, but I mean, this is first-year law stuff. The point is this, that negligent conduct with no damage, causing no harm, is the reason why it's not tortious. By contrast, the non-disclosure in this case has caused harm. It undermined Halliburton's confidence in the arbitrator's willingness and ability to conduct the reference with proper regard to Halliburton's legitimate interests in a fair process. It would have had the same impact on the fair-minded and informed observer, and it shows that the arbitrator is subject to unconscious bias. Now, in Al-Mazidi, and there's no need to turn it up for the moment because I'm going to come back to it in some detail later on, but in Al-Mazidi, this is in the Privy Council, authorities 0040 at 0914, the Privy Council made it clear in paragraph 28 of its judgment that in the circumstances of any case, and I quote, there is little, if any, scope for an argument that any lack of independence due to apparent bias did not matter, end quote. We'll look at that in due course. This also explains why it is irrelevant to view the position in the light of subsequent events. Subsequent events have no bearing on this issue. They are fortuities that tell you nothing about M or his decision to accept the second Chubb nomination or his failure to disclose the nomination to Halliburton. M conferred a potential benefit on Chubb at Halliburton's expense and failed to disclose it. None of that is affected by the subsequent events. Can I turn to say something very briefly about the overlap of the facts? What has happened here, that the parties very sensibly have agreed a statement of facts for your lordships, and that includes a chronology. That statement of facts is in the core bundle 043 at 0044. The risk of overlap between the two arbitrations judged at the time, and when I say at the time, I'm talking about the date in, I think it was December 2015 when M was appointed, is obvious. And if you have in mind in that agreed statement of facts, paragraphs 15 to 17, I'll just, if I may, very briefly summarise the points that come out of it. First of all, M knew the Transocean reference arose from the Deepwater Horizon incident, so he knew that both matters arose out of the same episode. Secondly, he knew it was a claim against Chubb under the Bermuda form, and in response to which Chubb was raising defences. And there were two defences that were common. First of all, that the policyholder's settlement was unreasonable, so what was being said in both cases was that Halliburton and Transocean had made deals or settlements with persons making claims against them, but that those settlements were said by Chubb to be unreasonable. He also knew that Chubb's decision to refuse consent to the settlement was itself reasonable. And then finally, there was absolutely nothing to indicate that the Transocean reference would be decided early as a result of a preliminary issue, because that matter had not even been adumbrated at the date when he was offered and decided to accept the Transocean appointment. Now, Chubb has supplemented the statement of facts with its own submissions on the facts. I'm bound to say some of the new material is not based on the evidence before Mr. Justice Popplewell or the Court of Appeal, and it is contentious. I'm not going to get involved in all that now, but it is in our Annex 1 of our supplemental written note. I may have to deal with it by way of reply, but not for the time being, but that is our position. I would add this, that there is a risk of being drawn into an elaborate examination of the similarities or differences between the two references. But that, in my submission, would actually be rather a pointless exercise. And it's worth bearing in mind Mr. Justice Leggett's observations in the guidance case. Again, I'll come to later on. The question should be approached, as he put it, with a measure of reality. And in guidance, you'll find that at paragraph 7 of his judgment, and the electronic reference is 10007. Could I turn next to say something very briefly about the legal test? It is well established. Lord Hope summarised the test for apparent bias in Porter and McGill. I'm sure we don't need to go to it because your lordships will be familiar with it, but it's in paragraph 103 of Porter and McGill, the authorities bundle 0267 1141, and he said this, and I quote, "Whether the fair-minded observer, having considered the facts, would conclude that there is a real possibility that the tribunal is biased. The facts to be considered are those relevant to bias, not facts that might provide post facto justification for the arbitrator's conduct." That's not a permissible way of approaching this problem. Lord Staines's later formulation in the case of Lawal, Lawal, against Northern Spirit, is in paragraphs 19 to 22, in particular at paragraph 21, where he said, "A fair-minded and informed observer would," and I quote, "consider that it was reasonably possible that the arbitrator may be subconsciously biased." And you'll find that in the authorities bundle 0165 and the relevant passage at electronically 1039. It's worth just pausing on Lawal, just to say something about the facts without it being necessary to turn it up. The question in that case was whether there was an appearance of unconscious bias. And what had happened was that the QC, who was appearing before the Employment Appeal Tribunal, had sat as a part-time judge with one or both of the lay members who were hearing the appeal that he was conducting as an advocate. This was apparently consistent with a long-standing practice which had never previously been questioned. The House of Lords concluded that there was an appearance of bias. It said that a fair-minded and informed observer should be aware of the legal traditions and the culture of the jurisdiction, but might not be uncritical of it. And you should look for this purpose at paragraph 22, which is at 1040 in the electronic bundle. And it reminds us that the fair-minded and informed observer is not one of us. She stands outside our legal tradition. She may consider our traditional approach to be complacent, too forgiving, or too trusting in the protection that integrity and experience can provide against the insidious effects of unconscious bias. The short point is that standards do change. And it's an interesting case, and the facts are interesting, and it shows you that something that for a long time had been acceptable, apparently, now no longer was acceptable. And I would add this, and based upon an observation of Lord Justice Ricks in the case of Kaur, K-A-U-R, against the Institute of Legal Executives Appeal Tribunal, paragraph 49. I don't need again to turn it up, but it's in the intervenor bundle, helpfully provided by them, 1221. And what Lord Justice Ricks said was that unconscious bias undermines justice because the biased mind will or may be unaware of its bias. And the quote was, "The need for the law to guard against the insidious effects of which those concerned are not even conscious," end quote. It's a very interesting and acute observation in my submission. Now, the fair-minded observer will be interested in the facts said to give rise to the risk of unconscious bias, not to the reputation of the decision maker. The essence of unconscious bias is that it infects the decision making of the high and the low, and there's no reason to believe that an eminent person is less subject to unconscious bias than anyone else. There's no such thing, and I think I've said it before, but I think it bears repetition. There's no such thing as a reputation for being immune to unconscious bias. In any event, there is no basis on which the fair-minded and informed observer will know of the reputation of the decision maker unless evidence is adduced on the point, and that is obviously not a road that we should even be contemplating pursuing. Now, could I say something about the arbitral process? Now, the informed and fair-minded observer will apply the test with sensitivity to the special challenges which arise in the context of arbitration. She is an informed observer. The informed observer will apply the test with a real-world understanding. She will understand the particular position of presiding arbitrators or chairs as opposed to party-appointed arbitrators. And now I'm moving on to a separate topic which your lordships, I'm sure, picked up in your pre-reading. She will not be put off being told that she is acting in a heterodox manner, which is the way it's put by my learned friends in paragraph 14 sub 9 of their written case. That's 0108 core 107, by taking into account matters that are not only relevant but notorious. We deal with the relevant matters in our written case at paragraphs 71 to 94, core bundle 073 0074. So in those paragraphs, and I'm not going to go to them and take you through them because it's all set out and I don't think I can improve upon them, you'll see all the differences between arbitration and litigation, and it'll all be pretty clear and self-evident, though I suspect it already is in any event to the whole of the court. But I should specifically mention the respective roles of party nominees and the independent chair. They obviously owe the same legal duties, and the same standard of impartiality applies to them. So we agree in these respects with the LCIA. Now, that said, it is objectionable that an arbitrator who's sitting as chair of one arbitration should then mix and match, as we put it, that role with another role as the nominee of one of the parties in a related arbitration. Mixing and matching is rare. It goes a step beyond what was proposed and rejected in Guidant by Mr. Justice Leggett. And as I said earlier, I'll come to Guidant, we'll look at it in some detail. Now, arbitrators earn their living by attracting party nominations. You will have seen in our written case at paragraph 80, Martin Hunter's remark. So Martin Hunter was once one of the senior partners of Freshfields, and along with Alan Redfern, writes one of the leading textbooks in arbitration law, Redfern and Hunter. And Martin Hunter's observation is rather crude, but it's interesting and revealing and realistic. He says this, that lawyers aim to appoint, quote, someone with the maximum predisposition towards their client, but with the minimum appearance of bias. That gives you a rather crude but spot-on description of what goes on here. You'll find that quote in core 074 at 0075 electronically. Now, this is really the ultimate form of forum shopping. The neutrality of the chairman against that backdrop then takes on a real significance in our submission, and that is recognised in the texts and was recognised by M. In our written case, paragraph 84D, at core 076 077. I think in that case, in that reference, M specifically talks about the importance of the position of the chairman as opposed to the wingman, but your lordships will see that in that reference. So there are particular concerns where an arbitrator chooses to mix and match his role as chair of one arbitration and as nominee for one of the parties in a related reference. And using, if I may adopt the formulation in Al-Mazidi in the Privy Council in paragraph 29, that's at 0915, the fair-minded and informed observer would say, quote, that surely cannot be right, close quotes. It undermines the delicate balance of the designed structure. Each party nominates one arbitrator, and the chair is chosen independently. Mixing and matching leads to the perception that one of the parties actually has two nominees to the other party's one. And the fact that party nominees and chairs are perceived to have subtly different roles, including by the arbitrators themselves, is accepted by commentators and practitioners. It is part of the system of party nominations.
So would it have been different if the second appointment had been as chair of the second reference?
It would certainly not have been different.
Your submissions wouldn't be different?
No, absolutely not. Absolutely not. In late 2017, my learned friend, Mr. Landau, who by chance appears, of course, in this case, was interviewed by a man called Mr. Prakash Pillai of Clyde & Co., and he was asked in that interview about the practice of party appointment, and it repays careful reading. I want to show it to you. If I can just find my copy. You'll find it in the responsive notes bundle 044. It's in tab 1 of that bundle. The internal numbering on the page is 25. It's quite a thin bundle, my lord. It's entitled Appellant's Responsive Notes.
Got it. Thank you. Page?
It's page 044.
Yes, thank you.
We've got a spare copy. We've got a spare. We can provide to
Yes,
you,
but
Lordship.
we can
with
share one between two in the meantime.
You sure? We can give you one.
Oh, well, if you can, that'd be very helpful.
If there's any offensive remarks in Mr. Kitchener's sideline, you just ignore them. It's only about me, apparently, the offensive remark. Have you flagged it? I think it's flagged.
I took the flag.
Oh, you took the flag out. 044 in tab 1.
Yep.
So PP is Mr. Prakash Pillai, and TL is my friend Mr. Landau. So PP says, I'll end with the final topic, which is party-appointed arbitrators. What do you think of the current system of party-appointed arbitrators? Do you think it's a moral hazard in the sense that you're getting your man to bat for you on the tribunal, which may lead to some sort of bias or unfairness? Or do you think it's an inevitable inherent part of the system that you have got to have that in order for people to sign on and actually proceed with international commercial arbitrations? Mr. Landau, I think on the one hand there's a mild hazard. I think there are serious problems in the process. But the second point is whether it's inevitable. I don't think it to be inevitable, but there is definitely a strong force to continue it because people like to have their choice. Party autonomy is the cornerstone of international arbitration. If you don't have that, you wouldn't have international arbitration. Broadly, to have your say in the way arbitration is conducted. And through that process, you want to have the ability to nominate the person you're comfortable with. Mr. Landau, I don't think it's necessarily true. You'd have your say by choosing an institution which has, for example, in it an established mechanism for appointing all three arbitrators. Pausing there, of course, most of the time what happens is that you have one side each with party appointed, and then the two arbitrators between themselves will appoint the presiding chairperson. It is still, that's not always happening, because sometimes there's a difficulty of agreeing it, and then ultimately, certainly here, you can go to the court. It is still party autonomy. Party autonomy doesn't equal you have to choose your own arbitrator. It just means you structure the process. It doesn't equal, but it is part of that in a general sense. I think those 2 points are related. This is the key to it. Why is it that people are so keen on having their choice of arbitrator? Here's the point. People want it because they want to secure a vote in their favour. That's what they want. There is, of course, an ideal solution, which is to have a neutral, high-level tribunal, but ultimately they want to win, and to win means collecting votes on the tribunal, and so you start by securing your first vote, which is your choice of arbitrator. That's what the system has become, and that means you invest a huge amount of due diligence and time and money in researching the arbitrator to try and predict which way he or she is going to vote, and make sure that it is going to be in your favour, and the other side will then do the same. Now that is very different from the ideal of a neutral tribunal. It is a tribunal. It's a tribunal that is stacked in your favour, and it puts a premium on how good your due diligence is and your ability to predict human nature, and that to me is a flawed system, and that is where we are at. Now, what's the answer to all of that? I mean, my own preference would be to do away, actually, if one could find a good way of doing it, to finish with party-appointed arbitrators. And I can tell you just my very personal experience when I sat as an arbitrator, and I am party-appointed whether I like it or not, being totally honest. It's a different feeling, fundamentally different feeling from sitting when I've been appointed by an institution. It just is, and that means that I am not sure everybody is honest about it. But if you're honest about it, and again, this is my experience, people may differ. I think that what it comes down to is you then feel that you have to resist certain forces when you are party appointed. You are resisting the temptation to be nice to the person who's being nice to you by appointing you. You're resisting the force of doing something which might uphold your reputation for the next appointment. You should not have those forces and pressures on you. When you are appointed by an institution, you're going to do the right thing. You don't have any of those issues. And then Mr. Pillai says, well, I think that's a view that's been articulated by a lot of people, and now there's a rising chorus of criticism about the system. Do you think the system is going to change? Are we going to move into a system of party-appointed arbitrators, or do you think we have to accept the defects in the system as part of life's realities? So Landau says, I'm not entirely optimistic that it will change. I think it's so ingrained, and I think it also is a question of trying to keep a level playing field. I mean, people will give up their choice if they're sure everyone else is going to give up their choice, and that requires a sort of universal change at one time. I think it's difficult to see how that's going to happen, actually. So in an ideal world, it will change, but at the moment, I'm pessimistic. Now, the fact that party appointees and chairs are perceived to have subtly different roles, including by the arbitrators themselves, is accepted, as I said earlier, by the commentators. Now, bearing in mind that little exchange, which is quite revealing and interesting, it's not surprising that the party appointee may feel differently from a non-party appointee. He's subject to, according to Mr. Landau, pressures and temptations. Those pressures and temptations go beyond the accepted and unobjectionable role of the party nominee referred to in our written case. Some arbitrators will be better at recognising those pressures and temptations than others. Some will be more successful than others at resisting them. But it's widely recognised as a problem. Notwithstanding that, and notwithstanding that exchange that I've shown you, in their written case, my learned friends say this. They say that it would be heterodox for the observer to take these matters into account. And you'll find that in their paragraph 14, sub 9, core 108 at 0109. So what they're saying there doesn't really stack up with my learned friend Mr. Landau's observations. Now, we summarise our submissions as to how the legal test should be applied to international commercial arbitration in our written case, paragraphs 91 to 94, in core 079 at 0080. And our criticism of the Court of Appeal is that it assumed what it was asked to determine, namely, whether the arbitrator was entitled to the unqualified trust of the informed and fair-minded observer. Or in the words of Professor McKendrick, and I quote, the Court of Appeal appears to take that trust for granted, and in that sense can be said to be somewhat complacent. And we quote this in our written case, para 65, core 071, and electronically 0072. Can I turn to say something more about the terms of appointment? You'll remember I drew attention to them at the outset, but I think we should look at them. You'll find them at 0608.
The hard copy, Lord Cabinet.
The hard copy,
Supplemental volume.
Supplemental 2, isn't it?
supplemental volume tab 17.
Thank you.
Volume 2, supplemental volume 2.
Thank you.
So, as I think indicated earlier, they're simply not referred to in my friend's written case. I think they're now referred to in something we got yesterday or the day before, but I mean, forensically, I can well understand that, but your lordships may think this is rather an important piece of paper. There are 2 points. First of all, as I have already shown you, clause 9, they contain an express prohibition on ex-parte communications. That's the thing that we looked at the outset of my submissions this morning. Secondly, they contain continuing duties of impartiality and independence, which you'll find in paragraph 7, which simply says that each arbitrator shall be and remain impartial and independent of the parties. So just as the duties of impartiality and independence continue for the duration of the reference, so must the duty of disclosure, as is implied by clause 8. Clause 8 provides the parties confirm that they waive any possible objection to the appointment of the arbitrators on the ground of potential conflict of interest and or lack of independence or impartiality in respect of matters known to the parties at the date of signature of these terms of appointment. So a clearer indication of the need for disclosure one couldn't imagine. There's also an express duty of independence. My learned friends in their written case point out that the draftsman of the Arbitration Act decided not to impose a statutory obligation of independence. They say that in their written case at paragraph 10, Core 104, 0105, and 21 sub 3, 0112. Now, I don't suggest that it makes any difference, but if it does, your lordships are now fully aware of the parties' contractual arrangements, which of course were binding on the arbitrators as well. If I can turn to make now really some submissions, insofar as I've not already done so, as we've been proceeding.
There is also, I think, clause 26, which has some bearing on the question of confidentiality, because the clause of the obligation of confidentiality is subject to other legal duties, which is relevant, I think, to one of the intervener's comments.
Would your lordship bear with me for a second?
Yes.
Yeah, indeed.
It's confidential, save to the extent that, reading short, disclosure may be required by a legal duty.
Indeed.
Yes. Yes.
Absolutely. So the two issues I've identified must be looked at together because the non-disclosure is closely related to the vice of accepting the second appointment. It aggravated the element of shared secrets between the arbitrator and his nominating party in Transocean. And the cumulative nature of these complaints is illustrated in Al-Mazidi. And I'd like to take your lordships to the judgment there. We can go, I think, direct to the Privy Council decision. It's in the authorities bundle 028 at 0902. Now, let me tell you about...
Do you happen to know which volume or tab?
Oh, very good point.
It's
Authorities,
Volume 2, tab 10.
Volume 1, Tab
Yes.
4.
Thank you.
So let me tell you about it first of all, before we turn to look at it. This was a challenge to Sir Peter Cresswell. Of course, at that stage of his career was already retired from the English High Court. It arose out of his concurrent appointments, first of all, as a judge in the Cayman Islands, and then at the same time as a judge in Qatar. It seems that he had never actually sat in Qatar or received any remuneration as a result of that appointment. I think Lord Lloyd Jones was a party to this decision, but I don't think any of the rest of the court were or was. So the question was whether Sir Peter could, in the Cayman court, hear a case involving Qatari parties. And at the back of one of these Qatari parties was somebody who would be in a position to influence Sir Peter Creswell's continuing appointment as a judge in Qatar. The similarity is that M was appointed by Chubb as its nominated arbitrator on Transocean when he was already engaged in the Halliburton arbitration. Now, Al-Mazidi concerned a winding up petition where serious allegations were made against Mr. Al-Mazidi. He was in a dispute with a Mr. Al-Emadi. The petition was granted by Sir Peter on the 20th of February 2012, and it was granted without any opposition. They didn't concede it, but they simply didn't oppose the application. Thereafter, Sir Peter dealt with various applications, including an appeal by Mr. Al-Mazidi against the liquidator's rejection of his proof of debt. The Cayman Court of Appeal held that Sir Peter was subject to apparent bias from the 26th of June 2013, when Mr. Al-Emadi became Minister of Finance in Qatar. And the point about the appointment of Mr. Al-Emadi as the Minister of Finance in Qatar was that in that capacity, one of his functions was that he had an influence over the appointment and removal of supplementary judges in Qatar, which would have included Sir Peter's position. Mr. Al-Amadi's predecessor in post was a man called Mr. Kamal, and he, inevitably I suppose in this context, was Mr. Al-Amadi's son-in-law. So they were very deeply related, and indeed the way that the Privy Council put it was this, and I quote, with whom he had a mutually supportive collaboration in almost every possible sense. And they said that in paragraph 31, authorities 0042 at 0916. Now, the Privy Council upheld the decision of the Court of Appeal, but ruled that the appearance of bias actually predated Mr. Al-Emadi's appointment as Minister of Finance, given their close relationship and the role of Mr. Kamal. So they took it back even to the time of Mr. Kamal's involvement, and you'll see that in paragraphs 33 to 34 in the authorities bundle 0042 0916. Now, of course, it was never suggested that Sir Peter would break his judicial oath in order to curry favour with the Qataris. That point is made at paragraph 18 of the judgment at 0910. But that was no answer to the allegation of unconscious bias. And that's an important point, because it meant that, notwithstanding his distinction, that didn't matter. What really mattered was the conflict position in which he found himself. And you can find that in the judgment of the Court of Appeal, paragraph 19. Go to paragraph 19. Under the indented quotation, it is true. This is, I think, this is Lord Mance's judgment. It is true, as the Court of Appeal observed, that this passage appears to focus on the risk of conscious rather than unconscious bias, and the fair-minded and informed observer would also consider the risk of the latter in the present context. Lord Bingham has already addressed unconscious bias in an earlier passage, which he then makes reference to and we're familiar with. And then towards the end of the next paragraph, the board does not take this passage to mean the fair-minded and informed observer would discount the risk of unconscious bias in all situations. The present case does differ from Prince Geoffrey in at least one respect. Court of Appeal did not mention. That is, in Prince Geoffrey, the matters complained of were institutional and public and affected judges generally in Brunei. In the present case, the complaint is that the judge had an undisclosed involvement in Qatar, of which no one else engaged in the proceedings was aware before mid-2014, by when his judicial activity in the Grand Court proceedings was almost over. And then in paragraph 32, in these circumstances, the board is in the invidious position of having to decide whether the fair-minded and informed observer would see a real possibility that the judgment of an experienced judge near the end of his career would be influenced, albeit subconsciously, by his concurrent appointment, which was at the outset still awaiting its completion by swearing in. The fair-minded and informed observer is in this context, and then there's some discussion about what the qualities of such a person would be. And then she or he must therefore be taken to be aware of the Qatari background, including the personalities involved, their important positions in Qatar, their relationships with each other, as well as the opacity of the position relating to the appointment and renewal of members of the relatively recently created civil and commercial court. And then it's all wrapped up in paragraph 34. In the result, the board, with some reluctance, has come to the conclusion the Court of Appeal was right to regard it as inappropriate for the judge to sit without disclosure of his position in Qatar as regards the period after 26 June 2013. This represented a flaw in his apparent independence. It also come to the conclusion that the Court of Appeal was wrong to treat the prior period differently. The judge not only ought to have disclosed his involvement with Qatar before determining the winding up petition, in the board's view, and at least in the absence of any such disclosure, a fair-minded and informed observer would regard him as unsuitable to hear the proceedings from at least 25 January 2012 on. The fact of disclosure can itself serve as the sign of transparency which dispels concern and may mean that no objection is even raised. An alternative to disclosure might have been to ask the Chief Justice to deploy another member of the Grand Court, to which there would, so far as appears, to have been no obstacle. So, the decision really of the Privy Council is encapsulated in that paragraph, where the two issues of the relationship between Sir Peter and the Qataris and the non-disclosure of that relationship were looked at in one place. The importance placed on disclosure is very similar to the observations of Lords Bingham and Hope in Davidson, and this is a general theme in the Privy Council's judgment. And it's also referred to at the end of paragraph 19. And paragraph 21. I don't think I referred to 21, but your lordships will read it in any event. Again, well, 21. Against this background, the Court of Appeal repeated an observation made earlier in its judgment, namely that although this was not the test of apparent bias, the judge ought to have disclosed his appointment in Qatar to enable the position to be clarified and considered and avoid possible later changes, such as the present. Mr. Francis Tregear, representing the JOLs, that's the Joint Official Liquidators, realistically did not take issue with this, and the board need say no more, and that it also agrees with it. Now, the judgment of the Privy Council in Al-Mazidi contrasts strongly in our submission with the approach taken by the Court of Appeal in the present case. The Privy Council stressed the significance of unconscious bias. For example, actually in paragraph 1 of the judgment, which again I'm afraid I didn't go to, but that's how the judgment begins, and your lordships should read that, but I don't propose to read it out now, and in the interest of time. But the Privy Council thought it made no difference that Sir Peter was a distinguished former judge of the High Court of England and Wales. They said that at paragraph 2 of the judgment. Nor the fact that he was approaching the end of his career. They said that in paragraph 18 of the judgment. And that does contrast with the reasoning of the Court of Appeal here and Chubb's written case, paragraphs 63, core 137 at 0138, where they persist in pointing to the quality of M and his reputation. The Privy Council regarded the fact of the judicial oath as largely irrelevant to the allegation of unconscious bias, just as the fact of the arbitrator's duty under Section 33 of the Arbitration Act is irrelevant. This contrasts sharply with the reasoning of the Court of Appeal. It's difficult to understand reliance on Section 33 and trust in the arbitrator, to trust the arbitrator that the arbitrator will comply with his Section 33 obligations. It has no bearing on the question of whether a particular decision maker is subject to unconscious bias. It's actually a non sequitur. If you say, well, I can't be biased because I'm going to comply with my Section 33 obligations, it doesn't actually answer the question. The Privy Council distinguished the separate Privy Council decision in Prince Geoffrey on the grounds that Sir Peter's appointment in Qatar had been undisclosed. But the tone of paragraph 20 of the judgment, which is 0911, shows that the Privy Council in Al-Mazidi might well have reached a different conclusion from the board in the Prince Geoffrey case. And it's an interesting point, but I think it's by the way as far as we're concerned, but your Lordships perhaps should have that in mind when you're thinking about the contents of your judgments. But there what was said was that the fair-minded and informed observer knows that judges, like anybody else, have their weaknesses, an observation with perhaps particular relevance in relation to unconscious predisposition. And what this demonstrates or illustrates is a developing, and we would suggest welcome, willingness to recognise the inherent vulnerabilities of human decision-making. And the Privy Council explained also that the uncontroversial nature of much of Sir Peter's judicial activity was irrelevant. It made no difference that the winding up order was essentially done consensually. That's paragraphs 25 to 28, 0913. And then paragraph 34 I've shown you, the Privy Council stressed the importance of disclosure, and it made clear that where concerns of this kind can be met by putting in place a different decision maker to whom no objection could be taken, that obviously is the preferred course, and that's a matter of common sense. 0917 is the reference to that paragraph. Now, in our case, we have the issue of multiple appointments that was disqualifying in Al-Mazidi, and we also have some aggravating factors. So what I'd like to do is to list compare the two situations with Al-Mazidi and our case. So first of all, Sir Peter had never even sat in the Qatari court or received payment for the appointment. M's acceptance of the second Chubb nomination inevitably led to his receipt of substantial remuneration. So our position is, so to speak, a worst case scenario. The Cayman Court of Appeal secondly held that it was likely that Sir Peter didn't even know of Mr. El Amadi's role in Qatar. That fact is recorded in the Court of Appeal judgment at paragraph 94. I don't think it's recorded in the Privy Council, but you will find it in the Court of Appeal. And that was one of the reasons why Sir Peter should have made disclosure, to allow the parties to educate him as to the potential risk of conflict. By comparison, M knew who was appointing him. Thirdly, in Al-Mazidi, some of the orders made by Sir Peter, including the winding up order, were effectively made by consent. Even those orders were set aside, and there's nothing comparable in our case. Fourth, M was appointed by one of the parties to the arbitration to sit in a related claim. There's nothing comparable in Al-Mazidi. Fifth, M's acceptance of the second Chubb nomination led, at least potentially, to all the benefits to Chubb and the disadvantages to Halliburton that the Court of Appeal said gave rise to legitimate concerns. There were no comparable concerns in Al-Mazidi. 6, M's nomination by Chubb to sit on the related arbitration was not a matter of public record. Unlike Sir Peter's, it was private information he shared only with Chubb and Transocean. 7, M's failure to make disclosure was a breach of a legal duty. So far as may be relevant, it was also contrary to international and institutional guidelines, including the IBA guidelines. And then 8th, decision-making by an arbitrator has none of the safeguards of open public judicial hearings, such as public scrutiny and the right of appeal, which obviously court proceedings do have. Now, in our written case, paragraphs 95 to 98, core 079, electronic 0080, we identify the problem that arises when an arbitrator, particularly a chair, accepts any new nomination from one of the parties. While the reference is ongoing, the nominating party pays half the fees. The nominating party has conferred a significant financial benefit on the arbitrator, regardless of who ends up footing the bill. And our concern, and that of the commentators, is that the benefit that the arbitrator conferred on Chubb was potentially an unfair one at the expense of Halliburton. And these problems have also been recognised in 2 cases at first instance. And that, for me, would be a very convenient moment, my Lord, because I'm going to go to the cases of Guidant and Boymer, which we'll have to look at. May I say also, I'm making very good time.
Thank you. We'll adjourn then for 10 minutes. Lord Grabner.
I'm grateful, my Lord. Lord, can I just come back on one point that Lord Hodge put to me earlier? I confess it's not a point that I had previously looked at, but no doubt I should have done. But your Lordship referred to paragraph 26 of the terms of reference, and it does provide an exception to in the sense that it says to the extent that disclosure may be required of a party or an arbitrator by a legal duty, etc.
Yes.
I mean, what it actually doesn't do is to tell you, well, what exactly can I do apart from saying, I've got a problem? And the kind of, the reaction that one would expect to get would be, I've got a problem, but I can't actually get into the detail of what that problem is. I can't show you the pleadings. I can't tell you what the facts of the case are. And so all it might actually do is to involve you in, some further litigation or some further dispute. But I think that's all that one can say about it.
Well, I wondered if it went further and meant that if you were correct that there was a legal duty to disclose the nature of the subsequent related appointment, that the obligation of confidentiality was qualified by that legal duty, requiring you to indicate everything that the other party needed to know.
Well, the trouble with that is that it would all be fact-driven, because it would depend upon exactly what the conflict was and what the particular facts of the case were. But beyond the fact of the appointment, it's very difficult to know exactly, without knowing, some factual context, exactly what the legal duty would require the arbitrator to do, beyond saying, well, I've got a problem.
Yes, but clearly your submission to this court is you want us to specify what the legal duty is.
Well, precisely.
Yes.
Yes, indeed.
But the reason I referred to it was one argument against this, your submission was that the idea that such disclosure clashed with the obligation of confidentiality. And I just wondered whether Clause 26 accommodated such a ruling, or could do.
My submission would be it definitely doesn't. It might facilitate a mechanism for dealing with the problem, but it doesn't actually answer the problem. Not more than that.
Yeah, thank you.
Do we know if there was a similar term in the contract of appointment for the second arbitration, the Transocean one?
On my feet, I do not know.
No. There has been shaken behind you.
We've never, ex hypothesi, we've never seen that.
Yes, of course.
Could I go to those 2 cases that I want to show you? First of all, the case of Guidant, which you'll find in the Authorities Bundle 0130. What's the Volume 1, Tab 7. Electronically, it's 1004. Now, in this, an interesting case. In this case, there were 3 Bermuda form arbitrations. The first was between Guidant and a firm called Markel Bermuda. The second and third were between Guidant and Swiss Re, the insurers. Guidant had appointed the same party arbitrator for all 3 arbitrations. In the Markel arbitration, the party-nominated arbitrators had agreed on my learned friend Mr. Collins, QC, as the chair. And in the case before the court, Guidant sought to have Mr. Collins appointed as the chair also in the 2 Swiss Re arbitrations. And Swiss Re objected on the basis of a concern that Mr. Collins might be influenced, or would be influenced, in deciding the Swiss Re arbitrations by arguments and evidence in the Markel arbitration, the first of the 3. But Swiss Re not being a party to the Markel arbitration, they would have no knowledge of the evidence and arguments in that arbitration, and they wouldn't be able to influence Mr. Collins through participation in it. Mr. Justice Leggett concluded that Swiss Re's concerns were well-founded. So Guidant said that it had legitimate reasons to want its preferred arbitrator appointed in all 3 references. They said it would minimise the risk of inconsistent decisions. And of course, Chubb makes exactly the same point in this case. Chubb refers to, and I quote, limiting the risk of contradictory judgments. They say that in their written case at paragraph 62.4. That's in the core 136, electronically 0137. And Mr. Justice Leggett observed that it was implicit in this argument that the arbitrator would likely be influenced in deciding one reference by arguments and evidence in the other. And he makes that point in paragraph 9 of the judgment, which is worth looking at. The learned judge says, in circumstances where the arbitrations will therefore be taking place separately, it seems to me that Swiss Re has a legitimate basis for objecting to the appointment as the 3rd member of the tribunals in its arbitrations of the same person, who is the 3rd arbitrator and chair of the tribunal in the Markel arbitration. If the same person were to be appointed, there would be a legitimate concern that that person would be influenced in deciding the Swiss Re arbitrations by arguments and evidence in the Markel arbitration. Indeed, the likelihood that that would occur is implicit in the very argument which Guidant makes, that appointment of the same person would minimise the risk of inconsistent decisions. Swiss Re is not a party to the Markel arbitration and will have no opportunity to be heard in that arbitration or to influence its outcome. And we respectfully agree with that. And I want to make 3 further points about Guidant. First of all, M's acceptance of the appointment to the Transocean Chubb reference put Halliburton in the same position as Swiss Re were held to be entitled to object to, so far as may be relevant in the context of a Bermuda form arbitration. So it's very closely analogous. And then in paragraph 9 of his judgment, as we've seen, Mr. Justice Leggett concluded that Swiss Re had a legitimate concern about the appointment of Mr. Collins and for that reason refused to appoint him. My learned friends say that in this passage, Mr. Justice Leggett is talking about a subjective concern. And in my submission, that's not a fair reading, a matter for your lordships. But the judge was really testing the point objectively, we respectfully suggest. It was a concern which, tested objectively by the court, was a legitimate one. If it was purely subjective and personal and idiosyncratic, then my submission is that the decision would have been different. Secondly, Mr. Justice Leggett made reference to the overlap point in paragraph 7. If your lordships would go to paragraph 7. Although Swiss Re has suggested in its evidence that the facts and issues are unlikely to be the same in all three arbitrations, and although it is right to say that Swiss Re has sought to rescind one but not so far the other of the two contracts of insurance to which it's a party, applying a measure of reality, and they're important words in my submission, there is bound to be a substantial overlap between the issues in all three arbitrations. It seems to me that that will inevitably be so in circumstances where the policies are in identical terms and cover the same risks, except as to the level of cover, and when, as the evidence adduced by Gardant indicates, all three policies were written upon the basis of the same application for insurance made by Gardant. So he noted that there were differences between the references, but he addresses the issue at a high level and applies the measure of reality. And this is the way, in my submission, that a fair-minded observer would look at the matter. To the extent that the degree of overlap may be relevant to assessing the facts said to give rise to an appearance of bias, there's no place for an over-fine analysis or a detailed, still less for a detailed post-facto investigation of the kind that you're invited to undertake by my learned friends on this appeal. My third point is that as a result of the failure to disclose, Halliburton was unable to object prior to M's acceptance of the nomination in Transocean by raising the objection that was successful in Gardant. And Mr. Justice Leggett then, at paragraph 10, said that the appointment of a common arbitrator did not by itself justify an inference of apparent bias. The point did not in fact arise in that case. He makes that observation, but the point did not arise in that case because he was looking at the matter in anticipation of an appointment rather than looking backwards in respect of an appointment that had been made in the past. So it was not the arbitrator who was making the decision to accept the further appointment and to confer any benefit on the common party. That question was being dealt with by the court for a decision in respect of how to proceed in respect of the future. M placed Halliburton in the position to which Mr. Justice Leggett said the non-common party could legitimately object. In fact, Halliburton had stronger grounds to complain because of the element of mixing and matching the position of chair and party nominee, which didn't arise in Gardant, because what they were looking for there was the same chairman for all three. And I would venture to suggest this, that Mr. Justice Flo, your lordships will recall that he was the judge who confirmed the appointment of M as the chairman of the Halliburton arbitration when there was a difference of position between the parties as to whether or not it was appropriate for him to be appointed. I would venture to suggest that if Mr. Justice Flo had had any inkling that M would accept a nomination in a related arbitration subsequently, he would not have appointed him to the Halliburton Tribunal. He would have reached the same conclusion as Mr. Justice Leggett. If M had given consideration to Halliburton's interests, he would have reached the same conclusion. Unlike in Gardant, the question of apparent bias arose directly for decision in the other case I want to show you, which is Boima, which is a decision in the TCC of Mr. Justice Fraser. You'll find that in Authority 0076, electronically 0950, which bundle? Tab 7 of the first bundle. My learned friends don't even mention Boima in their written case. So if I can just turn up my copy. Very old-fashioned bundle person, I'm afraid. Function of my age, I think.
I'm afraid I don't have quite the same excuse to the same degree. Right.
I'm in excellent company. And I just prefer to mark a document. So in Boima, the Court of Appeal does refer to Boima with apparent approval. It's just worth having a look at that. what I shall be saying is that they've implicitly overruled it. But they refer to it with what I would suggest is with apparent approval in paragraph 47. And they refer to an extract from it. I'm not going to go through it for present purposes, but what I would suggest is it looks as if there is apparent approval of the decision. But they do appear to have overruled it, but without giving any obvious reasons for doing so. So let's see what happened in Boima. A gentleman called Dr. Chern, C-H-E-N, was appointed as the adjudicator in two separate adjudications, which were both commenced by Boima in relation to works performed at Gatwick Airport. Some people called Vinci, V-I-N-C-I. Vinci was the respondent to one of the adjudications, and Vinci was unaware of the other adjudication, which was against a firm called Logan, L-O-G-A-N. Nor did it know, so Vinci didn't know, that Dr. Chern was the adjudicator in both adjudications. And in the event, Vinci successfully resisted the enforcement of the adjudication against it on the grounds of actual or apparent bias. And you get that from the judgment in paragraph 4, which is at 0951. But if you look at the judgment of Mr. Justice Fraser, he summarises the dispute. Just in the last few sentences of paragraph 4, Vinci opposes enforcement of the decision, relying upon breaches of natural justice, is the way the learned judge puts it. Other habitual offences were deployed, etc., but they're not relevant for present purposes. Now, the issues on the application before Mr. Justice Fraser are set out in paragraph 11 of his judgment. And he separates two issues. Issue 1, which your lordships can see there set out in 4 sub-paragraphs, but we're really concerned with issue 2. Issue 2 is split into 2 parts. Should Dr. Chern have disclosed to Vinci that he was acting as adjudicator on another matter involving Boima, at the same time as he was acting as adjudicator in the dispute between Boima and Vinci? And then B, if the answer to that is no, does the fact that the other matter concerns Boima and Logan on the same project and Boima's works for Vinci mean he should have disclosed this to Vinci? So, as I say, we're interested in issue 2, which the learned judge decided by reference to the right to an impartial tribunal. That's in paragraph 13, a little down the page. The rules of natural justice have 2 limbs. These are, firstly, a party must have an opportunity to present his own case and meet the case against him, and secondly, that the matter is decided by an impartial tribunal. It is the second of those 2 limbs that concerns bias, both actual and apparent. And now, if we could just have a look at some other paragraphs. 26. The learned judge says it's therefore necessary to consider the second issue before making findings about the correct approach upon enforcement to the advancing by Boima of 2 factually inconsistent cases. I mentioned this briefly earlier, that they told one story in one of the adjudications and a completely opposite one in the other one. Of course, the ignorant party wasn't aware of the fact that this had in fact been Boima's position. 27, in my judgment, Dr. Chern should have disclosed to Vinci that he was acting as adjudicator on another matter involving Boima at the same time as he was acting as adjudicator in the dispute between Boima and Vinci. This is the case regardless of the fact that the other matter concerned Boima and Logan on the same project. So it goes beyond the fact of, so to speak, the same kind of issues. It's much more than that. In my judgment, this failure to disclose his appointment led to a whole host of problems that either would not have arisen or, had they arisen during the adjudication, could have been dealt with as part of that process. Then in paragraph 30, perhaps your lordships could just look at that. The reference to AMEC there, which I think we'll come to at some later moment, but just for context. And then 31, if unilateral telephone calls are strongly discouraged, if not verging on prohibited, due to the appearance of potential unfairness, it's very difficult, if not in my judgment impossible, for an adjudicator to be permitted to conduct another adjudication involving one of the same parties at the same time without disclosing that to the other party. Conducting that other adjudication may not only involve telephone conversations, but will undoubtedly involve the receipt of communications, including submissions, and may involve a hearing. If all that takes place secretly, in the sense that the other party does not know it is even taking place, that runs an obvious risk, in my judgment, of leading the fair-minded and informed observer to conclude that there was a real possibility of bias. All of this can be avoided by disclosing the existence of the appointment at the earliest opportunity, with which, of course, we respectfully agree. And then paragraph 38. The learned judge says it's entirely correct to read Amec and Whitefriars, relied on by counsel, as stating that adjudicators can be trusted to approach matters with an open mind and to decide disputes only on the evidence and material placed before them on that particular dispute. And then after the indented quote, that dicta is directed at the second limb of the rules of natural justice, namely the impartiality of the tribunal. The something of substance here is the appointment of Dr. Churn in BL2 at the same time, and the conducting of that adjudication with all that involved in terms of contact with Boima, without notifying Vinci of that fact. Now, it's obvious in our submission, from paragraphs 27 and 31, that Mr. Justice Fraser's objection was to the adjudicator acting at the same time in two matters involving only one of the same parties. And for this reason, it was necessary for Dr. Churn's involvement to be disclosed. There is absolutely no suggestion in the judgment that one should wait and see whether there's anything in the secret communications before complaint could be made. The essence of the problem of secrecy is that ordinarily you will never know about the communications. And then in paragraph 38, Mr. Justice Fraser was stating a principle of general application. The reference to contact with Boima is a reference back to the concerns he expressed in paragraph 31, where he drew the analogy with unilateral telephone calls. Now, court procedures would not allow a trial judge to receive secret information from one party that couldn't be shared with another. That is the position that M put himself in when he accepted Chubb's new nomination in December 2015. It's unreal to suppose that M would be able to wipe his mind clear of information received and attitudes formed in the Transocean arbitration. I mean, suppose the evidentiary hearing in Transocean had postdated the evidentiary hearing in Halliburton, but had predated the Halliburton award. Why should it be assumed that M would have been able to compartmentalise his mind so as to take no account of information obtained or arguments heard in the course of the other reference, the Transocean reference? The mind is not a blackboard, or indeed these days a whiteboard, that can be wiped clean. That is, in my submission, a fiction. You can't do these things. There would be a risk of M being unable to divide his mind into hermetic compartments, and that is a risk to which Halliburton should not have been subjected without its consent, even more so without disclosure. And the Court of Appeal's main answer to its mistaken reliance on AMEC, and we can just look at that in the Court of Appeal judgment. This is at paragraph 51. (50 to 51 of the judgment). There's a long extract from the judgment of Lord Justice Dyson, and the Court of Appeal's reliance upon it, which I'm sure your lordships are now familiar with. We deal with that in our written case, and could I invite your lordships' attention to it, because I don't think I can or should try to improve upon what we say there. If you look at our written case, that's Core 89, electronic 0090, it's paragraph 120. So we say in our written argument, the Court of Appeal relied heavily and mistakenly on AMEC, and as we submitted to the Court of Appeal, the case does not help for the following reasons. One, AMEC concerned a second hearing with the same parties before the same decision maker. Neither party had privileged access to or shared any secret with the tribunal or enjoyed any other advantage. Secondly, there was no suggestion in AMEC that the tribunal hearing the matter for the second time could, would, or even should try to put out of its mind what it learnt at the first hearing, or the views that it formed following the first hearing. There was no unfairness to the parties in that regard. They were not entitled to a clean slate, but only to an equal opportunity to persuade, and that they had had on both hearings. And thirdly, AMEC therefore had no bearing on a case concerning secret communications between an arbitrator and only one of the parties, or the supposed ability of a decision maker to disregard the content of those communications. And there were no such communications in AMEC, so it really has absolutely nothing to do with related arbitrations or indeed our case. It has nothing to do with ex-parte communications, nothing to do with asymmetric risk, in other words, irrelevant. Can I just conclude by saying something about non-disclosure?
Before you move from that,
My lady.
Go back to an area that I used to be familiar with, because it seems to me that one of the foundations of this argument is the secrecy, and that isn't replicated on your argument in the judicial part of the legal system. But actually, there is an area in which it is replicated. Take, for example, a local authority proceeding in relation to a child that they may seek to take into care. Those proceedings will not take place in public. The judge may have heard from that same local authority, may have heard from that very social worker in another case, and that will not be known to the other parties in the new case.
Well, your ladyship has a serious advantage over me in terms of the context, but I assume that the reason for that is obviously that the primary concern of the legislation and the courts is the protection of the child, and that is the way that the system operates.
But the point is that if you're right about the impact of secrecy, it may have an implication for arguments in that context as well.
Well, I do understand, but my guess is, I'm completely ignorant of the particular area, but my guess is that that there presumably is some very special reason for that particular regime. But I do take your ladyship's point, which is that if that secrecy produces apparent bias or an unfairness, it may be that it's precisely the kind of situation that needs to be looked at again. And that's exactly what happened in Lowell, where for donkey's years, apparently it was the case that advocates would sit both as members of the tribunal and then go and argue cases in front of the people with whom they sat. That, in the light of subsequent analysis, turns out to be an unacceptable practice that had to be overturned. It may be the case here, I'm just not aware that there might be some other special feature which would justify
of course.
But if there isn't, then I would respectfully agree.
Something that you know and I don't. Can I ask you the page reference, please, if you've got it, for Mr. Justice Flo's decision of the 12th of June 2015?
We can give you that. We will give you that. So that was the decision when he
just interesting, Paul Stanley refers in his article to the fact that some of these bundles, for example, it's just worth.
Oh, that's interesting.
Yeah.
My friend Mr. Kitchener reminds me, though to be absolutely frank, it would be dishonest of me to suggest that it does remind me, that this question that your ladyship has just mentioned to me is actually identified in Mr. Stanley's article. This is in Authorities Volume 8, tab 195, and
Just what he does is identifies a whole bunch of features, including privacy, and
he just look at the question of privacy, and also in talks about youth courts that sit in private, and you'll find that at the relevant bit starts at A2289, and the bit that makes reference to youth courts is at A2292, and you may find that helpful.
Could you give me the MS number for that, please? Thank you.
And I'm told that Mr. Justice Flo didn't give a judgment. He simply made the order. No, the reference is the order. You got a reference to the order. We can give you a reference to the order, but we'll deal with that at the appropriate moment. So can I turn to say something finally about non-disclosure? So the Court of Appeal held that M was under a legal duty to disclose the relevant facts to Halliburton. There's a case called Soletanche, Soletanche, which you'll find in electronically 1577. Which bundle? This must be one of the recent bundles. There's just a very short point in it that I want to refer to, but Sir Michael Burton treated the proposition that...
Forgive me, which bundle is it?
Which bundle is it? Sorry. The electronic reference is 1577. The hard copy...
It says A0697 on the bottom.
Everybody got it? We think it's going to be volume 3 of the authorities bundle. Tab 67, I can hear being muttered.
Yeah.
Tab 67.
Yes.
That's it. Thank you.
But we're only interested in one paragraph 24. I'm not going to turn it up. But Sir Michael Burton treated the proposition as obvious, namely that there was a legal duty to disclose. He refers actually to the Halliburton judgment in the Court of Appeal. He said there was no doubt, and he said that even without the decision of the Court of Appeal in Halliburton, there would be no doubt that there was what he called a continuing duty to disclose. Now, Chubb says, well, what is the source of the obligation? And the answer to that in our submission is an implied contractual obligation. It is inherent in the agreement to arbitrate. It may, as in our case, be implied, in fact, into a written agreement, or it may be implied by law, like the implied obligation of arbitral confidentiality, which was explained in Ali Shipping Corporation against Shipyard Tregear. That's in the authority. Again, I'm not going to turn it up. I'll give you a reference. It's the judgment of Lord Justice Potter. The authority is 596, electronic 1470.
Volume 2, tab 60.
Volume 2, tab 62. And the relevant passage is at 1482, where the implied obligation of arbitral confidentiality was to be implied into a written agreement.
Lord Grabner, going back to Soletanche for a minute,
Lord, yes.
was Mr. Justice Burton there considering the question whether there was a legal duty to disclose in circumstances where there might be a reasonable apprehension of bias?
Standing on my feet, I don't know the answer to that question. Sorry? I don't think that it arose.
There's a reference to a continuing duty to disclose.
Yes. Yes, that's what 24 is about.
You're not relying on it as authority for
No.
further proposition
No.
that that duty arises when
Precisely.
when there might be a reasonable apprehension.
Yes.
Thank you.
Yes, indeed. So the, the statutory duties in the Act are the background to the implied obligation. The LCIA says the disclosure duty is to be derived directly from the duty of fairness. That's the way the LCIA put it in section 33. We, for our part, prefer the implied term analysis because the arbitration arrangements are basically contractual, so that would be the place where you would expect to find the answer. But either provides the answer to Chubb's query. And then the position in English law is reflected in universal arbitration practice, which is, and I've already made reference to this, the speech of Mr. Moore, which is in our written case, paragraph 133. The speech is electronically at 2906. The failure to disclose here gives rise to freestanding concerns. In Guidant, Mr. Justice Leggett held that the proposed appointment of the arbitrator chair in two related arbitrations was something about which Swiss Re could legitimately complain, but that complaint could only be made because Swiss Re knew what was being proposed, whereas Halliburton was in the dark. Guidance shows that the possibility of the Transocean appointment was something that Halliburton was entitled to know and to comment on. As in Al-Mazidi, disclosure would allow the ignorant party to educate the decision maker on risks of conflict. And there are other ways of looking at this story. First of all, the duty of disclosure on M was necessary to protect the party's interest in the integrity of the process. Secondly, the fact he should have disclosed were known to him and Chubb, but not Halliburton. Thirdly, his developing connection with Chubb was not disclosed. Fourthly, Chubb and M had a shared interest in the Transocean appointment proceeding without challenge. Fifthly, the non-disclosure exacerbated the problem that Halliburton would be unaware of the communications between M and Chubb in the Transocean reference. As a result, and again, as Mr. Rumsfeld would say, Halliburton did not know what it did not know. Whether Mr. Rumsfeld appreciated the significance of his observations, I don't know, but they're very interesting and revealing. It's a very interesting and revealing observation. As to the institutions, the ICC rules, the LCIA rules, and the IBA guidelines, they're all in the bundle, and they say much the same thing, namely that disclosure should be given of all matters that might call into question the arbitrator's impartiality or independence. The wording may differ, but the concepts are the same. Lord Bingham applied the same concepts in paragraph 19 of Davidson. Proper disclosure should be made of matters which, and I quote, would or might provide the basis for a reasonable apprehension of lack of impartiality, end quote. Perfect observation, as one would expect. In his separate observations, and I've made an earlier reference to the position of N, he commented on the importance of London as a seat because of its reputation for fairness. Neither of the arbitrations here was conducted expressly under the IBA guidelines, but they indicate the standards to be applied in international arbitrations. Mr. Justice Popperwell, in the Sierra fishing case, in paragraph 58, and that you'll find electronically at 1563. Have you got a bundle reference? Volume 3, tab 66, said this at paragraph 58 in respect of the IBA guidelines. He said, they provide illustrations of what the international arbitral community considers to be cases of conflict of interest and apparent bias. In his judgment in this case, at paragraphs 42 to 43, Mr. Justice Popperwell rightly said that the guidelines are not rules of law. Well, they are not. but he never grappled with great respect with the critical point that if applied to this case, the guidelines would actually have been breached. Breach of the guidelines should have troubled the judge, and in my submission, it should trouble your lordships. The reference in Mr. Justice Popplewell's judgment is to paragraphs 42 and 43 at first instance, and electronically it's 0219. So what we say is that where there is a significant failure to disclose, the fair-minded observer would consider there's a real risk that the arbitrator is not paying proper regard to the interests of the other party. Now, my lords, I've gone remarkably quickly, and I have done with what I wanted to submit to the court in opening. Unless there's anything more I can assist you with, could I perhaps put down a marker that I think I'm still entitled to 42 minutes by way of reply? Hopefully it won't be necessary, but could I perhaps reserve my position?
Yes, very well. Thank you very much, Lord Grosvenor. Mr. Kitchener, do you follow?
Yeah, well,
Mr. Crane?
Yeah, sure.
Lord, I think the order we contemplated was Mr. Venus going first.
Oh, I beg your pardon.
If that's...
Yes.
You're quite right. So, Mr. Particides, I think it's you.
My lord, it's Mr. Kimmins for the
Ah,
LCIA.
oh, you'll go first. Right.
I'm going to go first and then
Fine.
Particides. I've got 30 minutes, so I'll get cracking. I want to start with the big picture, if I may. It's fair to say that there has been some negative coverage and comment relating to the decision of the Court of Appeals. Yes, of course. Yes. I'm going to have to squeeze slightly to the...
You moved a step away.
Yep. There's been some negative coverage and comment relating to the decision of the Court of Appeal in this case. As far as the LCIA has been able to discern, there is a feeling in the international arbitration community that the approach of the English courts to the issue of apparent bias is insufficiently strict and insufficiently robust. Lord Grosvenor has already mentioned a number of articles, but I would recommend in particular that of Ewan McKendrick and Mr. Stanley. That concern has unsurprisingly caused concern in turn to the LCIA, the ICC, CIARB, all of whom have intervened and all of whom advocate in one way or another a stricter approach. And again, the highlight is what they're after is robust supervision by the courts. There are, of course, two other interveners, LMA and GAFTA, who take a slightly different approach. Their concern, though, at heart, is that if the appeal is allowed and at the same time the court sets down hard and fast rules of general application, then that could cause difficulties for them, and in particular, their specialist category of shipping and commodities arbitration. But for our part, we don't see that there are serious and irreconcilable differences between the two camps of interveners who are essentially saying the same thing, which is that apparent bias is fact sensitive. And of course, in LMAA and GAFTA, the facts will often be different given the well-known and accepted characteristics of those particular types of arbitration. But leaving aside LMAA and GAFTA for one moment, the LCIA is concerned to ensure that the default position in international arbitration is perceived to be sufficiently robust. Now, having made those introductory remarks, if I can turn briefly, first of all, to the test for apparent bias, and then I'll invite you to turn up the conclusions which the LCIA invites the court to make in relation to the two questions and deal with them one by one. Starting with the test for apparent bias, we don't say the test, the underlying test, should be different. We say it's the same. We've looked at that point long and hard, and after thinking about it very carefully, have come to that view. Nevertheless, we do say that the application of the test should take into account the distinctive characteristics of arbitration when compared to litigation. This was a point which was touched on by Lord Grabiner. The key points are, of course, that the arbitrators are nominated by the parties and have a direct financial interest in being nominated. And of course, that point, what one might immediately see is a possible answer to one question raised earlier about judges in local authority cases. Of course, you don't choose those judges, whereas you do choose your arbitrators. And that is a potential reason for differentiating between those two different types of case. But that's the first of the points. The second, of course, is that arbitrations are conducted in private and are confidential. And thirdly, arbitration awards are subjected to more limited powers of review. And the combination of those factors, we say, is powerful. And we do say that they are characteristics which should be taken into account in the manner in which the test of apparent bias is applied. Now, many, indeed, one might say most of those characteristics, we say, will militate towards taking a stricter approach in the context of arbitration than in the context of litigation. And the reason is that those characteristics give rise to a perception that there is a greater risk of bias in arbitration. Now, the respondents take issue with this, to which we say essentially as follows. Point number one, there is much writing in relation to this point. And just to give you an example, there's a reference to Jan Poulsen's book, which notes that dissenting opinions are regrettably almost always written by the arbitrator appointed by the losing party. And that's referred to in our written case at paragraph 13, footnote 18. And indeed, to tease the respondents a little, in their own written case, there is a Annex 1, which refers to jurisprudence from various jurisdictions around the world. And if I can quote from the law in Sweden in a particular case, it says, particularly high standards with respect to objectivity and impartiality must be met for arbitrators, since errors in their evaluation of evidence and in the application of the law cannot lead to the annulment of an arbitral award. Now, that is the third of the 3 points which I identified earlier as being unique characteristics of arbitration. And that one, we say, is a classic example of a characteristic militating in favour of a stricter approach. Now, as against that, of course, there are characteristics of arbitration which work the other way, and that must also be recognized. For example, it's clear that it is tolerated more in arbitration to have professional relationships with arbitrators. For example, there are conventions around the world. There's many of these in Hong Kong or wherever, recently, for example, in Hong Kong, whereby everybody gets together. And that is tolerated in arbitration, but one wouldn't tend to see the same thing in the context of litigation with judges. And again, there is jurisprudence which identifies that particular feature as going the other way. And so the point I want to make is the LCIA sees it as important to identify the precise vice that you are considering in order to work out whether to apply a stricter approach or a less strict approach. And we don't think that there's one answer. It shouldn't always be stricter. It shouldn't always be less strict. It will depend upon the context. Now, in this particular case, which bracket are we in? Are we concerned with contact at conferences in Hong Kong and the like? No, we're not. We're concerned with, we think, conduct which might be viewed with increased scepticism, given the fact that arbitrators are party nominated and that there is a limited right of review. So therefore, if anything, we think this is the case for a stricter application rather than a less strict application of those rules. Having made those preliminary points, if I can turn now, please, to the LCIA's proposed answers to the 2 questions. If I could ask you to take out our written intervention. It's the Intervenors Bundle 1, tab 4, and it's paragraph 39. So the electronic e-bundle reference is I/048. So that's Intervenors Bundle 1, tab 4, paragraph 39. And what I'd like to do now is just to quickly go through the proposed conclusions which we recommend in paragraphs 39 and 40 and explain our thinking in relation to those. So starting with paragraph 39, which is the suggested answer to issue 1, we say it depends on the facts. Now, that may not sound particularly illuminating in the context of this appeal, but the reason that we feel it necessary to seek that clarification is because, at least on one reading of the Court of Appeal's decision, the answer to that is no. It will not ever of itself amount to a situation giving rise to justifiable doubts. And we say it cannot be put that highly. It must depend upon the particular facts. And indeed, on one reading of the respondent's case, they too take the position that it can never of itself amount to justifiable doubts. And we say that must be putting it too highly, because there are, of course, two underlying vices, so to speak, which arise out of issue 1 and multiple appointments with overlapping subject matters. The first of those vices was one which was touched upon by Lord Grabbanner, and he referred to as shared secrets. But you'll see it referred to in the documents elsewhere as secret communications or something similar to that. There is, of course, the additional point described in the written cases as inside knowledge, which is slightly different. That is not so much concerned with the arbitrator's inability to put out of his own mind submissions which have been made secretly to him previously. That instead focuses on the position of the nominating party, who has had in effect a secret dress rehearsal. And it's the combination of those two factors, let me call them secret communications and inside knowledge, which we say mean that the answer to issue 1, as we have proposed in paragraph 39, is it might do, it depends on the facts. Certainly we say it puts it far too highly to say that it can never give rise to an inference of bias.
But if the real vice is dress rehearsal, that won't always affect the first arbitration.
Indeed, but it's the very acceptance of an appointment which has the potential to give a party a dress rehearsal that is the vice. So there is a timing point there, and that's a point taken by the respondents. They say, well, the inside knowledge point will all depend upon the batting order of the arbitrations, which one comes first. But I think our concern at the LCIA in response to that is, well, it's giving somebody the potential to have a dress rehearsal without disclosure that causes the problem. Now, there are, of course, some types of arbitration in which case it will rarely give rise to an inference of bias. And into that bracket, we put GAFTA and LMAA arbitrations, depending on the facts, of course. The well-informed objective observer, when assessing whether the underlying facts and conduct of the arbitrator give rise to justifiable doubts, will bear in mind what is expected and indeed desirable in the relevant context. So the machinery is there to deal with LMAA and GAFTA arbitrations and to put them into a particular category. Now, in relation to those, the LCIA considers it to be of significance that they have specific rules which appear to recognize that this is something which can and will happen in those types of arbitration. So, for example, in LMAA, one has specific rules dealing with concurrent hearings, and the tribunal may order concurrent hearings against the will of the parties. And that in itself recognizes that the multiple appointment with overlapping issues and one common party is something which can happen. and therefore, again, it goes to the party's expectations and enables one to put GAFTA and LMAA into a particular bracket. Now, as to where insurance and reinsurance lies, that's obviously a matter for the court to take into account. But for our part, we do see much force in what the appellants say on this point in paragraphs 26 to 35 of their note on the interventions. Just to give you a reference, it's N/009 to N/012.
Paragraph numbers were, sorry?
That's paragraphs 26 to 35 of the note on the interventions. And this wasn't a point developed thus far by Lord Grabbanner, but that's where they seek to grapple with the distinction between insurance, reinsurance, ad hoc arbitrations, which of course is what we're concerned with here, and GAFTA and LMAA, where both parties have agreed to buy into a particular regime. And that is, of course, something that doesn't necessarily get in an ad hoc arbitration without institutional rules, etc. So if I could take you back then to the written submissions at page 16. I've dealt with paragraph 39. Paragraph 40, little 1, we say there, although the test under section 24 may reflect the common law test for apparent bias, the distinctive features of arbitration should be taken into account. I've dealt with that point. If I could go on, please, to 40, little 2, and deal with the experience and reputation of an arbitrator, something that was touched on by Lord Grabbanner. We do think that there are 4 reasons why little or no weight should be given to reputation and experience, and they are as follows. The first point is that the LCIA is concerned about how reliance on reputation and experience in these courts ends up looking to the outside world and to users of London arbitration. Apparent bias, of course, must be assessed through the eyes of the objective observer, not the judge considering the issue. And there is a perception, we feel, that there is at least a temptation and perhaps a tendency for judges to give undue deference to experienced English lawyers, QCs and judges, etc. And in these circumstances, we think there is a danger of the English courts being perceived to be overly complacent. The second point is this, that we think there is a tension between giving weight to an arbitrator's reputation and experience whilst at the same time affording that arbitrator anonymity. Now, it may be that this point falls away, given the panel's indications at the beginning of this hearing. But if one puts oneself in the shoes of a US insurer, for example, who looks on at this case, and he doesn't know who M is, he isn't allowed to know who M is, but he's told by an English judge that M has impeccable credentials, and he's meant to be satisfied by that. Now, he might find that puzzling, particularly in circumstances where justice not only has to be done, but to be seen to be done. Now, as I say, it may be that that point falls away, depending on any subsequent ruling in relation to anonymity. The third point is that we query to what extent experience and reputation is actually a relevant factor at all. And there we make 2 points. The first is to echo one made by Lord Grabbanner, that the very essence of unconscious bias is that one is unaware of it, and therefore experience and reputation is less likely to be an answer to that particular point. But a second point, and a subsidiary point, is that there are certain vices which experience and reputation of an arbitrator will not do away with. For example, consider the issue in this case of inside knowledge. Inside knowledge is the advantage that an arbitrating party gets by the secret dress rehearsal. And the arbitrator's experience has no bearing on that point. The advantage has already been bestowed upon the party concerned. So that's the third point. The fourth point on reputation is this, that we feel that there are real practical difficulties in considering issues of reputation and experience, which make it difficult to judge and indeed invidious to judge. Is an English judge less prone to bias than a judge from another jurisdiction? Is there a difference in their training? How does one deal with this? And to take a pragmatic example, GAFTA in this case have submitted that their arbitrators are well qualified, which of course is right. But how does one test that? Does one have to dig out the training manuals and make sure that X attended on all days of that training? Does one have to have cross-examination or some kind of evidence in relation to these points? We think that these types of issues do not lend themselves to being easily determined in the context of challenges. And that is why we think there is much to be said for simply doing away with reputation and experience as being a relevant factor, particularly when combined with the first 3 points that I mentioned earlier. Now, we take some comfort in reaching that conclusion from the IBA guidelines in a slightly different context, but the guidelines say that they apply to lawyers and non-lawyers alike. And we understand the thinking to be behind that, the thinking behind that to be similar to the thinking which I hope I've just explained to the panel. In other words, one shouldn't have different rules depending on one's legal training and abilities and all the rest of it, not least because it's an invidious exercise. Now, ignoring reputation and experience altogether does away with all 4 of the problems I have identified at one stroke. The alternative might be to give less weight to reputation and experience, but the problem is all 4 of them then come back into play to a greater or lesser degree. And therefore, there is something to be said for the bolder proposition of simply doing away with it as a relevant factor altogether. Now, I'm conscious that there are some authorities which have said that experience and reputation are relevant, and we mention these in our document. There is the Saudi cable case and the Pakistan case, and they're all dealt with in our submission. The respondents also rely on the Al-Mazidi case, at paragraph 32, but Lord Grabiner took you to that. And for our part, we're not convinced that Al-Mazidi deals head-on with this particular point as to the weight to be given to reputation and experience. Now, that's all I want to say about reputation. If I can then take you to 40(3) on page I/048 of our submission and deal very briefly with the third point we make there. We say the test should be applied in the same way for party-nominated arbitrators as for the chairperson of the tribunal. We've heard what Lord Grabiner says in relation to that point, but we stick to our guns on that. Lord Grabiner said, and I quote, that a party-nominated arbitrator and chair are, quote, perceived to have subtly different roles. Now, that is not a perception which the LCIA shares. We think they can and must be seen in the same light, because otherwise we think one goes down a slippery slope into recognizing that different standards will apply to them. It is difficult to see how logically one can sensibly distinguish between a chairperson and a party-appointed arbitrator, save to say that different standards apply. And that is the difficulty we have with that, and we support on that point the respondent's written case, which is at C108.
It occurs to me that in subject to what's said, that the exercises that, for example, Mr. Landau described in the interview isn't to do with bias, even unconscious bias, but to do with the fact that different people look at things in different ways. And, for example, if you were trying to choose a panel of this court, and you were acting for the government, for example, you might choose a different panel from the panel you might choose if you were acting for an asylum seeker.
Indeed.
And no doubt you could do a computer analysis of how people have voted, as it were, in cases of that kind over the last 10 years and have make an informed decision.
Precisely.
But it wouldn't mean that anybody on the court was biased or not biased, but they might have a different approach to the application of principles of judicial review. Or the same point might be in relation to the construction of contracts. There are people who prefer Lord Hoffman's approach, people who prefer Lord Sumption's approach.
Indeed. Indeed. So the difference is between being biased and being predictable.
Yeah.
And the example you give is one that comes up a lot in arbitration, that of the black letter lawyer, in that if you are faced with a case in which the document, the contract that you're trying to construe doesn't particularly help you, you may want what are known in the industry as a merits man. Or you may want a black letter lawyer if you're on the other side of the equation. But that's about being predictable, not about being biased. And that is why we think one cannot draw a distinction between party-nominated arbitrators and the chair. They're all in the same boat to that respect.
In terms of standards, sorry.
Well, I was going to say, I should hasten to add that my experience is that people are, in fact, a good deal less predictable than one might have imagined.
I can see why you say what you say in terms of standards, but is there any content in Lord Gravener's point that in maintaining standards, different types of arbitrators may come under different pressures?
Well, that troubles us, that proposition, as to where it goes, because we can't see that it goes anywhere unless it carries with it an inference that a party-nominated arbitrator is to be approached slightly differently. And that seems to us to open a Pandora's box. There are certain jurisdictions which historically have recognized that party-appointed arbitrators are different and have applied different tests, the US in particular at one point or another. But we don't see that as an attractive option. In our view, what it does is essentially marginalize the two party-appointed arbitrators. They become bit-part players who are meant to do what their appointing party does, and then it's up to the chair to decide the case. One ends up with a one-person panel. So we think it's a slippery slope, and we don't see much room for fine distinctions along the lines of those made by Lord Gravener, because we worry where they go.
It could be said that you have to concentrate on the fair-minded observer looking in from the outside, and his perspective may not be the same. He may see people who are bound by the same standards but coming from different directions because of their appointment.
It may be that in practice, and to this extent Lord Gravener has a point, it may be that in practice I would have to accept that there are people out there, and it may be, if you ask 10 people, a significant number would say, well, I would expect my party-appointed arbitrator to bang the drum for me more than the rest. But I think it is, as a matter of principle, too dangerous a route to go down to start recognizing a difference between them. We think that we would suddenly end up, potentially, with the US-type system, which we think is unattractive. And as I say, we'll end up marginalizing the party-appointed arbitrators. There is also something very inherently unattractive at recognizing that an arbitrator who is judging a case is to be forgiven for banging the drum of his appointing party. I
don't think I was suggesting that. I was saying the standards can be seen as the same, but there may be pressures on different types of arbitrator which differ. That was my point.
Yes, I understand the point. Yeah. I hope I've made...
I understand your answer as well. Thank you.
In relation to that.
Thank you.
And I mean, there are all sorts of reasons why you might have nominated arbitrators. And I'm just thinking of a case in my own experience where there was an international dispute, and one party nominated a civil lawyer, one party nominated a common lawyer, and the chair was to be a lawyer from a mixed legal system.
That's very common.
And, there's no particular reason to expect, I mean, none of them was, as it were, the client of the person nominating them. But they're each bringing a different expertise to the the exercise.
Indeed, that's very common. It's common to have a QC, a civil lawyer, and a judge, for example. There's nothing unusual about that at all in the context of international arbitration. One gets that often. I've gone as far as paragraph 40, little 3, and given the time, I'll move straight on, if I may, to the next issue, issue 2, which is dealt with in paragraph 42, which is page I/049, where we deal with non-disclosure. As to the first point, paragraph 42(1), we do say that there is a legal duty of non-disclosure. We say that the Court of Appeal was right to find that there was. Now, pausing there, the first question one needs to ask oneself is where does this point actually go, given the positions taken by the various parties? As far as we see it, whether or not there is a legal duty doesn't affect the consequences of a failure to disclose. So to be clear, we say that even if there is a legal duty, breach of that duty has no automatic consequence. It doesn't automatically disqualify an arbitrator. It's simply a factor relevant to whether there are, in fact, justifiable doubts as to impartiality. Now, having said that, as far as the LCIA is concerned, we think that recognizing a legal duty sends an important message. Arbitrators are more likely to disclose when they recognize they are under a statutory obligation to do so, and the LCIA considers that to be of importance. Now, where does that duty come from? Lord Grabiner has identified what one might describe as the implied contractual analysis. For our part, we prefer the Section 33 analysis. But just to be clear in relation to a point Lord Lloyd-Jones made, we are here referring to the obligation to disclose facts which might give rise to justifiable doubts. And that's important because one has to be cautious to avoid bootstraps arguments in relation to finding a duty in favor of the obligation to disclose those facts. We say that the simplest home for that duty is Section 33 of the Arbitration Act and the duty to, and I quote, act fairly and impartially as between the parties. We think that to act fairly between the parties, both parties must be made aware of facts which might give rise to justifiable doubts, because it is only in those circumstances that the parties can consider their position and assess their options. They may take the view that having regard to this fact, which might give rise to justifiable doubts, they want to take a punt and challenge the arbitrator. But they have to be given that opportunity. And that is why we say there is a legal duty to disclose what might give rise to justifiable doubts. Now, having got that far within the context of Section 33, one then asks, well, where does one go within Section 24? And a point is taken by the respondents to the effect that, well, if you're dealing with a Section 33 breach of the duty to act impartially, you are shoehorned into Section 24(1)(d), and therefore you need substantial injustice. And this isn't a substantial injustice case, therefore that's the end of the appeal. We think that that unduly restricts the possible consequences of a breach of Section 33, because, of course, Section 33 on its face refers to the duty to act fairly and impartially. There must, therefore, be the possibility of a failure, a breach of Section 33 relating to partiality, and that takes one straight and neatly into Section 24(1)(a), and therefore, in effect, there are two options available to you if there is a breach of Section 33, depending on the facts. You may argue that you go into Section 24(1)(a) and seek removal. You may argue that you go into Section 24(1)(d) and run a substantial injustice removal argument, or indeed you may go to Section 68. And that, of course, does require substantial injustice and allege a procedural irregularity. But the point I'm trying to make is it cannot be said, we say, that a breach of Section 33 and the duty to disclose cannot be relevant to whether or not the arbitrator should be removed under Section 24. One must have at least the option of alleging that the relevant facts, in particular the failure to disclose, in breach of Section 33, takes one within Section 24(1)(a). So that's what we say about the source of the duty. The respondents say, well, if Section 33 or rather, if the draftsman of the Act did intend there to be an express duty, then they would have said so. And I think our answer to that is, well, we're not so sure. Either we're within Section 33 or we're not. It rather begs the question as to whether or not there is express mention of that particular duty. The respondents also say, well, how can that apply to someone who hasn't yet been appointed? Because the Act only applies to an appointed arbitrator. And to that we say, frankly, so what? It may well be that the duty to disclose only arises after appointment, but that in no way militates against the existence of such a duty. It may also be that, practically speaking, arbitrators may choose to give disclosure before appointment, knowing that they are under a legal obligation to do so afterwards under the Act. And again, we say that that has no bearing on whether or not there should be a legal duty under Section 33. So we think that that particular section does provide the neatest solution to the issue of whether an arbitrator is under a legal duty to disclose. Now, I can deal with the remaining points more briefly in the few minutes remaining before lunch. In our paragraph, let me get the right one, apologies. I should have been in paragraph 56. I may have taken you to the wrong paragraph previously, for which apologies. I'm on page I/054, and I'm looking at the LCIA's suggested answer to issue 2. And we've looked at little 1. The last sentence of little 1, we say there is a duty on the arbitrator to make reasonable inquiries. We do think that's an important point. There is arguably a paragraph within the Court of Appeal's judgment which says there is no duty of inquiry. We would ask the Supreme Court to look carefully at that to make sure, again, that the wrong message is not sent. We think there obviously is one. There's a different point, of course, as to whether an arbitrator should have constructive knowledge. We don't say that, but we do say that the arbitrator should be obliged to take reasonable steps, and that a failure to do so may, in and of itself, amount to factors giving rise to justifiable doubts. If I can then take you on, please, to little 2 of our paragraph 56. First point we make is that the duty in any given case is a fact-sensitive question. I don't think I need to develop that any further. And the final sentence, we refer then to LMAA and GAFTA. And again, we do say that as far as they're concerned, they may well fall into an entirely separate bracket, given the various rules which the parties have signed up to. In little 3, we deal with the consequences of a breach, and we say that, and this echoes a point Lord Grabiner made, that one never looks at a failure to make disclosure in isolation, because, of course, you are failing to make disclosure of, at the very least, something which might, of itself, have given rise to justifiable doubts. So one can't divorce it from the underlying issue, which is the underlying facts themselves. And so one can test it this way. One might end up with some factors which didn't quite reach the would category and are still in the might category. But one then has a failure to disclose something which fits in the might category, which tips it cumulatively into the would category. I hope that's clear. Yeah. It doesn't sound it. So that's our little 3. And then a final point, just for the last minute. we worry that the fact that non-disclosure is innocent is given too much weight. We think it is very rare indeed that one can ever prove a deliberate non-disclosure. And we make no criticism of that. That is simply a result of English courts' quite right, natural reluctance to make a finding of bad faith against someone without having heard them cross-examined. And so it is very rare that one ever finds a finding of deliberate non-disclosure. In those circumstances, we worry that too much weight is given to the fact that a non-disclosure might be innocent. We think that that is essentially a neutral point. Now, of particular concern to us is the possibility of combining reputation and an innocent non-disclosure, and using those two mechanisms to dismiss a challenge which would otherwise be strong. And if we were to point at two factors in the Court of Appeal's judgment, which we think were cumulatively given too much weight, it is reputation and the innocent nature of the non-disclosure. And we don't think those are a card which can be waived or should be waived, with the result that challenges are inevitably dismissed. I see it's now 1 o'clock, and I've said all I wanted to say, so I'll sit down.
Well, thank you very much. We'll sit again at 2.